All right, Chris Dimakos is going to join us in just a sec. He's our CJAD 800 legal contributor. I will point out today, I know we've been talking a lot about employer-employee issues there. Today's is a little different. Today's is about divorce, specifically a divorce suit. This one based in Ontario. So, Chris, let me start with this by asking the question, maybe it's not that odd, but typically divorce proceedings, by the time you get to court, you've been through a whole lot of negotiations. Both sides have lawyers. How unusual is this one to have sort of ended up the way it did, with basically the court sanctioning the ex-husband here?
Yeah, so many times when you have something as emotional as a divorce, it's taxing on everyone, the families involved, and sometimes there are individuals who want to use this opportunity to get back at somebody, to make them feel the pain that they're going through,
right.
and sometimes they use the legal system to do so, whether that be by filing, useless motions or making outrageous allegations. In this case, we have the ex-husband who was making allegations about the wife, doing stuff on the internet that there was no proof of her doing that, just to try and muddy up her name and make her feel embarrassed in court. So the judge said, "Hey, listen. What you're doing here is in bad faith. Not only are we going to have you pay a substantial part of your legal fees, but we're gonna divide the family patrimony in a different, and not an equal partition. But we're gonna take that into consideration that you were in bad faith." So, I put some of the blame on that individual's lawyer for not letting them know. Listen, if you're going to take this approach, I understand that you're hurt, and I understand that that's what you want to do. But you better be prepared to have consequences if this thing doesn't go the way you want it to go. So it's really important, if you're going through divorce proceedings, anytime you feel like you're being led by emotion, anytime you feel like you're angry and you want to do things because you're angry, that can cost you a lot of money. And sometimes even more than that, it can cost you things that are even more important, like how much you see your kids or the circumstances surrounding how things are going to be separated. So, again, it's a highly emotional field of law when you're going through divorce. I would say, sometimes you're better off trying to settle this early. Even if you feel like you're not getting a good deal, trust me, the long term, you're probably going to be better off.
To your point, Chris, that's interesting. You mentioned a second ago, he has a lawyer representing him in this particular case. And I'm imagining the lawyer, any lawyer would say, look, I understand, as you just said, you're angry. But this idea of not being able to control a client, your job is to tell them that's not going to get you anywhere. In fact, if you really upset the judge, if you allege these things and don't have proof, it's going to end up costing you money. That's just completely ignored here?
Right. And you know what? I've had experiences where I've noticed that sometimes lawyers, as long as you pay the bills, they'll do what you tell them to do. And in terms of your responsibilities, sometimes you have to tell your client, hey, we're not going to go down this road. I know this is what you want to do. I know. And sometimes that means the client saying, if you don't do it, then I'll go to somewhere else.
Right, exactly.
Sometimes that means letting that client walk. But at the same time, you got to do your job, and you got to let them know this is not the road you want to go down. It's not going to end up well for you. I don't want to be sitting next to you when we're going to be having this type of judgment handed down. So sometimes it ends up being that. It ends up you saying, it's either we do this the right way, if not, you got to find yourself another lawyer.
By the way, not that it's important, but it's kind of important. You talk about the allegations here. From what I understand, the husband here going through this divorce, the ex-husband, alleged that his wife was secretly earning millions of dollars as an internet porn star. Would that be, if you bring up millions of dollars, would the idea be here that he would be entitled to some of that money? Do you think that might have been the impetus here?
That's absolutely what he was alleging. He said that the child support should be reversed, there should be unfair partition of patrimony because she was making all this money and not declaring it. But when it came down to showing proof, he had pictures, but you weren't able to identify her. It was basically ridiculous. The courts came down hard on this individual and said, you can't do what you just did. If you're going to make these types of allegations, you got to have enough to substantiate at least somewhat what you're saying, and there was nothing like that in this case.
By the way, so I'm playing my lawyer, putting on my lawyer hat now. Could the ex-wife in this case have simply also gone ahead and sued for damage to her reputation by virtue of this?
Well, two things. One, in fact, you're absolutely right to think that. That's a good reflex. The only thing is, in family court, it's not public, so people cannot identify the parties in a family case. So In terms of her reputation, that suffered very limited damage because no one, even we don't know what her name was. They just use initials when they identify the parties.
Second one here, completely different story, but again, maybe good advice for people listening, maybe going through something like this. It's about a couple participating in mediation with lawyers to try to resolve a divorce, but nothing ends up here being signed, and then what happened?
Right, so they participate, they come to some sort of agreement where they agree on principle on certain matters. The mediator sends out an email saying, can you just review what we agreed on here and then sign it? One of the parties starts regretting what they agreed to and didn't want to sign it, ends up going in front of the judge. The judge says, listen, this was the agreement that was had. Even though there was no signatures, there was a meeting of the minds. Everyone there agreed to it. They were represented by lawyers during the whole process, and the court said it's in the best interest of everyone involved that this thing gets resolved. It's resolved in a fair way. I don't see why we should open this up. So, again, this is a very, very particular case. But what you should take from this, if you're listening to it, is when you sit down with your lawyer and you go through a mediation session, it doesn't necessarily mean that you have to agree to what is said. But if they pass it around and everyone acknowledges that this is what they want, you have to understand that you can't just say, well, as long as I don't sign this, I'm not going to be bound by it. That's not the case. And by the same token, just because you sign something and you're not advised, that doesn't mean it's an agreement. So the important part to retain here is make sure you're well informed and make sure that whenever you decide to make a decision or voice your opinion on something like, yes, I agree or no, be very certain that you're comfortable with it. And if you're not, say, you know what, we covered a lot today. I'd like to have a couple of days to sleep on this and look it over with my lawyer when I'm not in the presence of everybody. Make sure you don't leave that meeting saying, okay, it's good for me, and then have second doubts when you leave there. So, again, take the time to understand all the different aspects of any agreement you're at, and only sign when you feel comfortable with it. Because, like we see here, even if the parties didn't sign, the fact that they voiced their consent and said, we agree, everything is good, we'll wait for the official papers to be sent out, that was enough for a judge to say an agreement was reached.
So basically this idea of signing, if you don't sign, that's not even applicable. Clearly in this case it wasn't. You're simply saying, I didn't sign it, so that must mean I didn't agree to it, and the judge said, never mind, too bad?
The judge said, based on the lawyers that were there, based on the emails that were sent, based on the text messages that were sent, there was a meeting of the minds. Everyone agreed to these terms. Yes, there was no formal signature, but all of the language and the messages and the testimony by everyone involved suggested that they all agreed. Now, one party decided to change their mind afterwards. Now, that's a whole different legal scenario. But again, what you should take from this case is just because you don't sign something doesn't negate what you said or what your language would be or what your lawyer said for you. If they said we have an agreement, even if it's verbally, if they acted like it, if they sent text messages to the fact that there was an agreement, the fact that there's no signature is not enough to say there was no agreement. So be very, very conscious of that when you participate in these mediation sessions.
Good to know. All right. Chris, thank you very much. Appreciate it.
Thanks, Aaron.
Chris Dimakos, our CJAD 800 legal contributor.